In this video, we'll discuss regarding judicial review and the very exact meaning of judicial review. Judicial review, in short, is the authority of the courts to declare void the acts of the legislature and executive if they are found in the violation of the provisions of the Constitution. Judicial review is the power of the highest court of a jurisdiction to invalidate on constitutional grounds the act of other government agencies within that jurisdiction. And now we'll go to the origin and development of judicial review. And as it was in the case of United States of America, the doctrine of judicial review has been originated and developed by the American Supreme Court, although there is no express provision in the American Constitution for judicial review. But in the leading case, Marbury versus Madison in 1803, Chief Justice George Marshall expressed that American Constitution, even though has no express provision of judicial review, but it had the power of judicial review, as there is supremacy of the Constitution in United States of America. Therefore, in case of conflict between the Constitution and the acts passed by the legislature, the courts follow the Constitution and declare the acts to be unconstitutional and therefore void. The courts declare void the acts of the legislature and the executive if they are found in violation of the provisions of the Constitution. And now we'll go to England. As you know, there is the very supremacy of English Parliament. So in England, there is supremacy of Parliament, and therefore the act passed or the law made by Parliament cannot be declared to be void by the court. And now we'll go to the very position in India. So the Constitution of India expressly provides for judicial review. Like United States of America, there is supremacy of the Constitution of India. Consequently, an act passed by the legislature is required to be in conformity with the requirements of the Constitution, and it is for the judiciary to decide whether or not the act is in conformity with the constitutional requirements, and if it is found in violation of the constitutional provisions, the court has to declare it unconstitutional and therefore void, because the court is bound by its oath to uphold the Constitution as it was expressed by the apex court or the Supreme Court of India in the leading case A.K.Gopalan versus State of Madras in 1950. So the Constitution of India, unlike the American Constitution, expressly provide for judicial review. As we'll analyze Article 13 Clause 1, Article 13b, 13 Clause 2, Article 32, Article 226, Article 131, Article 132 to Article 136, and Article 143 to clarify the exact constitutional provisions which directly provide the very concept of judicial review. So, Article 13, Clause 1 provides that all laws in force in the territory of India immediately before the commencement of the Constitution of India, insofar as they are inconsistent with the provisions of Part 3 dealing with the fundamental rights, shall to the extent of such inconsistency be void. And Article 13 Clause B provides the state shall not make any law which takes away or abridges the fundamental rights, and any law made in contravention of this clause shall to that extent of the contravention be declared void. And Article 32 provides remedies for the enforcement of the fundamental rights in case of infringement of rights. Fundamental rights, the right to move the Supreme Court itself is a fundamental right as provided under Article 32. Besides, in the case of infringement of fundamental rights, the aggrieved person may move the High Court as under Article 226, which empowers the High Court to issue writs, directions, or orders in the nature of habeas corpus, mandamus, certiorari, qua warranto, and prohibition for the enforcement of the fundamental rights as well as ordinary rights. And Article 131 to 136 provides original and appellate jurisdiction of the Supreme Court. So, according to Article 131, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute between the government of India and one or more states, or between the government of India and any state or states on one side and one or more states in the other side. And Article 131, 32 to 136 deal with the appellate jurisdiction of the Supreme Court. According to Article 136, the Supreme Court may, in its direction, grant special leave to appeal from any judgment, decree, determination, sentence, or order in any cause or matter passed or made by any court or tribunal in the territory of India. However, the said provision of Article 136 shall not apply to judgments, determination, sentence, or order passed or made by any court or tribunal constituted by or under any law relating to armed forces, And Article 143 deals with the advisory jurisdiction of the Supreme Court. The opinion of the Supreme Court gives under the advisory jurisdiction under Article 143 will be binding on all the courts in the territory of India other than the Supreme Court. So, in that context, we would like to discuss the very important leading case Indira Nehru Gandhi versus Raj Narayan in 1975, where it was held that the constitutional mode of judicial review, and in that particular context, as we found that in the very case regarding the appeal of matters relating to election, as it was under the 39th Amendment Act, there was exclusion of the election of Prime Minister and Speaker as such, and the Supreme Court held that it is not beyond the judicial review of the Supreme Court. So, these are the developments of judicial review in India. And as it was originated and developed by Chief Justice C.J.Marshal in the famous leading case Marbury versus Madison in 1803 in United States of America. And as in case of England, even though the Parliament is supreme, but the administrative authorities, they are under the review of judiciary for their actions, but not the acts or enactments passed by the English Parliament. So, in our next upcoming video, we will definitely discuss regarding the finality clause or ouster clause, how it is being applied in case of judicial review of legislative and executive acts or orders.